matters that I may have to clarify, although some of them have been clarified. So the first leg has to do with this assertion, which was beginning to gain grounds, that why is it that the OSP traveled to United Kingdom? It's important that we also deal with it, because it's been thrown about as if we are very...
So tell us why.
We are very unfair and unreasonable. The OSP had issued Interpol Red Notice for 4 British citizens, including Samuel Mahama. And it had become apparent to us after 5 years or more that the UK authorities were unwilling to enforce the extradition. So because they were British citizens. So there had to be mutual agreement for us to be able to go onto their soil and do investigation. You know, you cannot just go to another country and just start doing investigation. It's unlawful, you can't do that. So that's one of the reasons. The other leg I want to talk about is trial in absentia. I've also noticed it being thrown about. And I've been wondering, where is this coming from? Because if you read Article 19.3, there are 2 conditions under which you can try someone in absentia. The first one is that the person's character is very disruptive. And then the second one is that the person, after being placed, after becoming an accused person, decide not to appear in person. So if you look at Article 19, absconds. So if you look at Article 19.3, in all the cases, they are accused persons. As we speak, Ken Ofori-Atta is not an accused person. He is a suspect. And if I've heard some people also go to Act 30 and they quote Section 60 and says that
Act 30 is our criminal procedure.
Criminal procedure. You can file charges and just let it go. And if you check, those of you who have your Act 30, just look at it. It only says that, it only gives you the criminal procedure processes. It says that you can do so by a warrant or you can do so by a summons. Now, when we say a warrant, it means that the law enforcement agency will go to a court of law and will file. Sometimes you go by a motion, sometimes you go by affidavit and the police extract. And then you will detail the offense for which you are looking for the person, and then it will be granted you. Or you go by the second process where you go to a district court judge where you file a complaint, and a district court judge will then issue a warrant for police to carry it out. So either way, you come back to the same process where a person has to be taken through the process of arrest. So when they talk about trial in absentia, I'm like, wait a minute. Why don't you let us finish with the processes of arrest before you then bring in trial in absentia? But it's being bandied around as if the OSP is unreasonable.
So a person must get to the point of being named as an accused.
Yes, then
before you can consider trial in absentia, and not when they are suspect.
Yes, they've been confusing the complaint you file under Section 60 of Act 30 as if that is what gives you a process to do a civil. No, that's because the judge will still have to issue a warrant for the person to be arrested. And in all these 2 scenarios, whether by a warrant straight away by the law enforcement agency in court or by a summons, you still detail the offense for which you are looking for him. Some people have said that we have not filed any. Well, of course, we have a warrant for Ken Ofori-Atta, and a warrant is based on an offense, using public office for profit, if people have not seen it. And then there's another one about because you put him on Interpol or because we list him on our wanted list, it means we've done something wrong. Law enforcement across the world have 2 procedures. Before we declare someone wanted, we will go for a warrant from a court of law. So it's not true that OSP just issues a warrant.
When did you get a warrant for this? Because that has become an issue.
I think somewhere in February. That's when we went for the warrant for Mr. Ofori-Atta.
Okay.
Warrant is taken
for arrest.
Purposely to arrest you.
Yeah, so not to declare him wanted.
You cannot declare a person wanted. I know you come in. Let me help him here. You cannot declare a person wanted when you are not searching to arrest the person. Yes. The only reason why so let me go back. The OSP, IOCO, and the Ghana police, they do not require a warrant to arrest a suspect. We don't need it. Act 30 says that we can arrest you with a warrant or we can arrest you without a warrant. The only reason why sometimes we go for a warrant is to cure all doubt. Sometimes you go, they are very violent and all that. So we go for, and then the most crucial one, if you find us, go for an arrest warrant. It means that we are not able to locate you. So we want people to help us arrest you. And the only way to do that is to be able to get around the warrant and then declare you one. That's why you even have the FBI wanted list. And they have the most wanted list. They even have 2. And people are placed there all the time. It doesn't mean that you have abused that person's rights.
So, as we understand, this warrant is actually in the courtroom now, and this is the warrant that the OSP is referring to. So you can see warrant to arrests. Then you find it the Supreme Court of Ghana.
I don't even think we should display this to the public.
But it's already in the courtroom, so we know it's a matter of public.
Yes.
And it's issued on the 12th day of February 2025. Okay, go on.
So
quickly, I beg you.
I know
you just said that.
Wait, let him finish.
But some information there was problematic.
And so yeah. So the whole point is that when we declare someone wanted, law enforcement agencies have intrinsic power to also project such a person so that whoever finds the person can bring the person to, especially in country. And that's what the OSP does on its website and on its social media handle. It's done everywhere. So when the OSP does this and it appears a group of people are trying to project as if we are being unfair, I don't even understand, because it's a standard procedure.
When Bentil spoke about that here, he's not speaking about just the OSP. He's saying that like all other law enforcement are doing this, as far as he's concerned, it should not be done. He's not saying only OSP does it.
No, I'm
because we know that all the other law enforcement agencies, they do this.
So I was always responding to.
Okay.
Then when we cannot find you in country and you're outside, that is when we activate the Interpol Red Notice. The Interpol system is just to help law enforcement across the world, 196 countries, so that we can. So I cannot find you in Ghana, but I can find you in UK. They will arrest you, hold you there till an extradition process comes in and brings you back.
In this case, you know his whereabouts. In this case, his lawyers have written to you. In this case, you know that he's unwell. So why the red notice asking how many countries to be searching for him?
I would have loved that his lawyers were here to answer a few questions. I'm sure that with the processes in court, we'll be asking some questions again. But if you say that we know where he is, if we know where he is by the say-so of his lawyers, right? So, and we also have our own intelligence. There are not a lot of things that we can tell the public. So the fact that they've said that he's in the United States, and I know that on Joy News, you did try to ask him whether the lawyer, which part of the United States, and he wouldn't even tell you. But suffice to say, the only letters that the lawyers have brought to the attention of the OSP was, so let's do the chronology. In February, as you are aware, after we pressed him, he did bring a definitive date and a timeline. He said he was going to do a surgery in March. He didn't say he was going to do diagnostic procedures, as the doctor was alluding to. Diagnostic procedures is when you do the biopsy and all that. He didn't say that. He said he was going to do a surgery, 21st March. That's when the OSP gave him some time. And he said he would need 1 month to recuperate. And his doctor actually said that. So we gave him time. So you need 1 month, we'll bring him to April. But we said that come 2nd June, we gave him. So you see that they wrote to us on 28th February. That's some 3 days ahead of the press conference to say that in that letter, they even acknowledge that we have indulged them, because the lawyers start by saying that, thank you for indulging us. And then they go ahead to say that he has prostate cancer and that he won't come because he's slated for a surgery. They don't attach any medical record. It's just the piece of letter that they bring. No attachment, nothing. They don't tell us about what happened in March. Was he able to do the surgery, and why didn't he come? Nothing of that sort. And then suddenly we see another piece of letter from a hospital addressed to nobody to whom it may concern. Because remember, the OSP currently is the law enforcement agency that's at least that has come out to say it is investigating you. I know others are also investigating him. But if you want to address us, then an official letter must come from Mayo Clinic addressed to the special prosecutor and then detailing whatever is going to. Now,
you're saying you have received a letter, but your problem is that it's addressed to whom it may concern.
I've said that we have received a letter through his lawyers that details that he's going to do a surgery without any medical record attached with. Then we have seen a second letter that they leaked through Asase Radio and spread all over. In that letter, we see a letter that is coming from a hospital, but that letter is addressed to whom it may concern. And I'm saying that even if that is the purported medical letter, it can't even be a medical letter because it is merely a letter stating that he will go through a surgery. And I'll come back to something very soon.
They suggest that this letter is in a stash of documents in which you must know that it is available to you.
That's what I'll come to. I'm saying that piece of letter which we have seen, that letter even is not addressed to the special prosecutor or to a court. It is to whom it may concern from a doctor that has signed. Of course, we know Mayo. Mayo is a place where you can even bring your own doctors from anywhere. They grant you the facility to use it. So our point is that we have checked even Mayo. I did my research, not even the office. And I noticed that at Mayo, a patient, they have said that they don't want law enforcement or family members to bombard them with cross-checking things. So Mayo has an online portal that says that a patient has the right to give third parties access. So if, for instance, Mr. Ofori-Atta wanted us to see his medical record, all he needed to do is to grant us access. Mayo says that once the patient grants you access, you will see the entire medical report.
I've seen that as well.
Yes, so it's online that he could have chosen, but he didn't.
Right.
Now we are told that on the 27th, they filed an affidavit, a supplementary affidavit, because they've already in court trying to get the court to declare that we had declared him wanted without an arrest warrant. We have produced to the court that we declared him wanted with a warrant. They have filed a supplementary
affidavit. We have shown that warrant to the world now.
They filed a supplementary affidavit in which they are seeking, among other things. But in that supplementary affidavit, it was filed on the 27th, but it was served on the office somewhere on Tuesday or Wednesday. So it was not before we did a press conference. That's why we said that we didn't see. But in that supplementary affidavit, they list a number of documents they've attached. And in that supplementary affidavit, which I have a copy, I can let you have a look at it, they don't attach a medical record, although the letter from the purported doctor lists some attachment. But nowhere in the court document have they attached it. And it now makes sense to us in the letter that came from the lawyers to us. They had indicated that if we wanted to see his medical record, they could meet us somewhere and show us. Or they could let the court know and then we'll go to court and view it. Our point is that it is not us who have to show anything. It is you who is seeking excuse. You have to take that steps and show us. In any case, our point is that in all the letters that we have seen, nowhere in the letter does it say that Mr. Ofori-Atta is incapacitated.
Okay.
And something, just finally, our point is that you can be sick, but you still have to face law enforcement. The only time you can say law enforcement should excuse you is when, one, you are bedridden. Two, you can't even talk. You can't move. Nothing at all. You can't travel. The question we're asking that between February and June 2nd, has Mr. Ofori-Atta traveled or not? Has he been sick on a hospital bed in Mayo from February up to now? Because his letters are conflicting. The current letter says that he finished diagnostic procedures in March. Now, if you finish diagnostic procedure in March, then you have April, May, June to have come to us before your next surgery.
Question, why can't you do a video conference with him?
I thought I had answered that. The point is that for you to take a caution statement, and that's why the special prosecutor says something, that it appears that suspect Ken Ofori-Atta is trying to tell the OSP how one to arrest him how, one, to investigate him, and 3, how we should conduct our work. That is not up to him to say. Now he sends us a letter and says that, I want you to take my caution statement through video conferencing. How do we take a caution statement when we have not even taken you through any arrest procedure? And how do you know that it is just a caution statement we want to take from you? We are the ones doing the investigation, and we say that your presence is needed. Other than that, Samson, this is what is going to happen. From what he's telling us, everybody in Ghana, including Wuntumi, when Yoko said he should come, all Wuntumi should have said was that, oh, if you have evidence, things against me, go to court and file it. Don't come to me. So the hundreds of people who have been arrested by police today, all of them should tell Ghana police that, I don't need to come before you. Go to court and file your charges, and then I will come there and send my lawyers there. That would be absurd.
Can't you make an exception, or you are afraid that when you do that, you open the floodgates?
It's not about exception. It's about what the rules are. And I'm trying to say that the rule is that you must go through a certain procedure before you can take a person's caution statement. We are not done with that.
Okay.
For instance, we cannot arrest him through Zoom.
Okay.
And if we can arrest you by law, we cannot take a caution statement from you. That's why...
But the OSP itself has said that whether or not he makes himself available, you are proceeding to press your charges at the last press conference.
Yes, he did say that. He talked about trying absentia, but it has to be understood in context, which is that we would have done the Interpol process, which is an arresting procedure and all that, and we'll be able to move ahead with that.
So you must first hit a snag with all the processes. You must exhaust all of it.
Yes, we must do something like that before that. So I want to state on record and to tell Ghanaians that the OSP has been very fair and professional in handling. Mr. Ofori-Atta is not the only person who we are investigating. As we speak, there are over 30 people who are on bail right now that nobody knows about them. And yet they will be facing charges very soon in court. But nobody has heard about them. They are on bail. They are the only ones who know that they've come before OSP.
Okay. Right. Now we know that you guys, what you do is invitation. You don't go arresting people. But when you invite us, we know that you are going to arrest us. Now we know.